let's all stand. Federal Court of Australia is now in session. Be seated, please.
Yes, call the matter for judgment, please.
NSD 103 of 2023, Bruce Lehrmann, Network 10 for judgment.
There are no real winners in this litigation. The result is best characterised as the respondents overcoming a misconceived claim in relation to a broadcast because they were able to prove at trial the substantial truth of what the contemporaneous material demonstrates that they considered to be the less substantial allegation made in the broadcast. Of course, with the predictability of an atomic clock, partisans have focused solely on those parts of the judgment that happen to align with preconceived notions, but the reality of mixed findings has been somewhat obscured in the public statements of the respondents and their submissions as to costs, which advance an assertion that they won the litigation and that costs should axiomatically follow the event. Understandably, strong criticisms of Mr. Lehrmann in his conduct of the litigation have featured prominently in the written submissions filed on this application and do assume decisive importance. However, at the urging of all parties, I dealt with all pleaded issues rather than simply deciding what turned out to be the determinative justification defence. At the risk of repeating matters canvassed at length in my judgment, it's appropriate to commence these reasons by making 2 points relevant to the conduct of the respondents. First, in section K of the judgment, I explained why the conduct of both Network 10 and Ms Wilkinson in publishing the project program, it has character of defying the defamatory imputations as to Mr Lehrmann, was unreasonable. Contrary to the assertions of Network 10, the examination of the respondents' conduct was not devoid of nor divorced from reality, nor did it involve picking apart and dissecting the respondents' conduct by reference to a standard of perfection. For anyone taking the trouble to read the judgment would conclude that I did not consider the evaluative assessment required by the statutory qualified privilege defence to be a close-run thing. I also explained that although the respondents legally justified their imputation of rape, their conduct was not justifiable in any broader sense. The material in evidence is replete with the recognition by the project team that the major theme of the broadcast was the publication of what Mr Shiraz, the promoter of the project, and the regular conduit between Ms Higgins and Mr Llewellyn had pitched to Ms Wilkinson. The credulous approach taken as to the allegations pitched by Mr Shiraz and as to Ms Higgins' credit generally lacked both rigour and objectivity. None of this can be separated from the approach taken to the publication of the imputation of rape on the material then in the possession of the respondents. Contrary to the recent assertions of Network 10, a publication is not reasonable simply because it turns out to be true in some respects. Secondly, there's the behaviour of Network 10 justifying aggravated damages being the conduct relating to Ms Wilkinson giving the Logie speech for the reasons it was given. I will come back to this issue briefly below. Against the background of all my findings, not just the findings critical of Mr Lehrmann, it is now necessary to deal with the balance of issues that require resolution before this court's involvement with this controversy concludes. This involves answering the following 3 questions. 1, should Network 10 obtain a costs order, and if so, what should it be? 2, should Ms Wilkinson obtain a costs order, and if so, what should it be? 3, what orders should be made to resolve the cost position as between the respondents? Before addressing these 3 questions, it's also necessary to make some additional factual findings, and I also set out in the written reasons some principles relating to costs. Only one offer of settlement was made. When one has regard to the evidence adduced at the hearing, the reason for this seemed clear. In the cross-claim judgment, I refer to the fact that on 7 March 2023, Ms Higgins instructed her solicitor to send an email to the solicitors acting on behalf of Network 10, which asserted, amongst other things, the following stipulations. 1, it's important for your client to appreciate that Ms Higgins is doing so, that is, cooperating with Network 10, on the basis that your clients will not offer Lehrmann a payment of damages or a retraction of the defamatory statements or an apology or costs or any other relief to settle the civil claims commenced by Mr Lehrmann against your clients. And secondly, for the avoidance of any misunderstandings, Ms Higgins instructed her solicitor not to assist lawyers and counsel retained by Ms Wilkinson. I then put those stipulations into some context by reason of communications between the solicitors for Network 10 and the agent of Ms Wilkinson. I refer to the advice given by Mr Walker as Senior Counsel and Mr Patrick George that the stipulations made in exchange for the cooperation of Ms Higgins were at the least unwise and showed a lack of regard for the complexities of representation in the proceeding. Moreover, although not relevant to the advice, one of the stipulations was also unwise because, if agreed to, it would have the apparent consequence relatively early in the life of the proceeding of fettering the ability of Network 10 to compromise the dispute. This is significant because under Section 37N1 of the Federal Court of Australia Act, all parties were required to conduct any negotiations for settlement of this dispute in a way that is consistent with its quick, inexpensive and efficient resolution. It is apparent an offer by Network 10 to resolve the dispute in the manner like that adopted in the compromise of the two related proceedings, or even settling the case with a partial retraction or the most nominal contribution towards costs, would have been inconsistent with Ms Higgins' proposed stipulations. I then refer to the fact that Ms Wilkinson referred to these stipulations a number of times in relation to her communications with Ms Wilkinson's agent. No evidence was adduced before me as to whether Network 10 entered some formalised agreement with Ms Higgins by which it expressly agreed to the conditions purported to be imposed by Ms Higgins in exchange for her cooperation as a witness. But by reason of the fact that Ms McGarvey, on behalf of Network 10, at least twice expressly referred to the conditions as a reason why Ms Wilkinson should replace her chosen senior counsel, it appeared to me available to infer that what might be thought to be the appropriate response to Ms Higgins' solicitor was not conveyed. That would have been to say, with respect, that if Ms Higgins did not wish to cooperate with Network 10 without imposing conditions upon representation of a party and potential settlement options, then Ms Higgins will need to be subpoenaed and shall be obliged to assist a court of justice in coming along to tell the truth until excused. The inference that Network 10 acted in accordance with the stipulations of Ms Higgins also gained apparent support from the fact that on 31 August 2023, the respondents jointly made their only offer to resolve the proceeding, being a walk-away compromise by which A, the proceeding be dismissed without any admission of liability, and B, that there be no order as to costs between the parties. It is not in dispute that the offer, if accepted, would have required Mr Lehrmann to give up his then accrued right of a costs order obtained during the limitation extensions argument. Hence, it would have involved no amount being paid to Mr Lehrmann, even though he then had the benefit of a costs order made against Ms Wilkinson 4 months earlier. Needless to say, no party is required to settle a case, and the respondents in the end were vindicated in the sense they obtained judgment on the statement of claim. The current point is a more subtle one. It is whether Network 10, if accepted the conditions sought to be imposed by Ms Higgins, would be acting contrary to its statutory obligation to engage in settlement negotiations in accordance with the overarching purpose. Albeit without the benefit of evidence, I am told, notwithstanding Ms McGarvey twice referred to the conditions these conditions in her dealings with Ms Wilkinson's agent, no cooperation agreement was formalised, and the conditions proposed by Ms Higgins did not inform Network 10's subsequent actions relating to compromise. Despite the inferences available on the evidence, I accept the assurance of senior counsel that this was not the case. The potential brief of the obligations to engage in efforts to compromise the dispute in accordance with the requirements of Section 37N1 was a matter of preliminary concern relevant to costs. But given what I've been told upon instructions by Dr Collins of King's Counsel, it's unnecessary to reach a final view as to the appropriateness of a party accepting such conditions sought to be imposed by a third party in exchange for cooperation, and this issue can be put to one side. In any event, Mr Lehrmann preemptively rejected the offer in less than 2 hours, and there is no evidence of any counteroffer being made. I then deal with a series of relevant principles and then deal with the question of costs of Network 10. Mr Lehrmann did not advocate for a particular order, but noted it may be appropriate to recognise the success the respondents have enjoyed in the litigation, but having regard to the fate of the qualified privilege defences, temper that success by ordering the applicant pay only a proportion of the respondent's costs on an ordinary basis. Having noted this, Mr Lehrmann accepts that it's open for the court to order Mr Lehrmann pay the costs of the respondents on an indemnity basis. Network 10 accepts it is relevant to have regard to all of its conduct up to the date of judgment, but asserts there is an insufficient basis upon which it would be an appropriate exercise of discretion to deprive Network 10 of an order for costs. Further, Dr. Collins stressed that notwithstanding the court concluded that certain comments made by Network 10 spokesman immediately following the delivery of judgment mischaracterised what the court had found, any such post-judgment conduct was an irrelevant consideration when it comes to awarding costs. Although I'm not convinced any post-judgment conduct could always be irrelevant to costs, for present purposes I do not consider any mischaracterisations of my judgment are material to the exercise of the present cost discretion, and I accept it must be put to one side. When one returns to the relevant conduct, Network 10 makes three main points. First, reliance upon the outcome and findings made as to the statutory qualified privilege defence ought to be treated with caution in circumstances where it was entirely counterfactual. Secondly, despite some strong indications of the unreliability of their main source, the project team was correct to believe Ms Higgins' core allegation as to the rape. Thirdly, the findings themselves in the judgment do not amount to a failure by Network 10 to comply with the overarching purpose. The pleading and prosecution of the separate statutory qualified privilege defence was not doomed to fail, and it was not the dominant issue in the proceeding. All these points have some merit. Having said that, while it's correct that particularised aspects of the conduct examined in relation to the Section 30 defence were not found to be improper or mala fide, such as to justify aggravated damages, one cannot ignore the fact that the relevant conduct of Network 10 relating to the publication of the project program was far from reasonable, and the statutory qualified privilege case, while not hopeless, was weak. I raised with Dr. Collins whether the appropriate exercise of discretion, leaving aside the basis upon which any costs would be paid, would be to make an order for costs, but only costs relating to the conduct of the substantial truth defence. In response, Network 10 submitted that there must be exceptional circumstances to warrant depriving a successful party of an order of the whole of its costs. It is important not to be too prescriptive about the exercise of a broad discretion, particularly by reference to principles introduced into the law prior to the introduction of Part 5B of the Federal Court of Australia Act, and absent the present need to have regard to facilitating the promotion of the overarching purpose. In the present case, and while having regard to the applicable principles, the relevant issue material to my discretion is best expressed as being whether the persistence in advancing the statutory qualified privilege defence was consistent with the overarching purpose obligations, and whether the issues it raised were sufficiently clear and severable from the other issues. The evidence on the cross-claim makes it clear that the solicitors knew from the outset the statutory qualified privilege defence faced formidable challenges, and I make reference to some evidence to that effect. With some reluctance, however, and despite my reservations as to whether the persistence of the respondents in pursuing the statutory qualified privilege defence did facilitate the efficient and cost-effective resolution of the proceedings, I have concluded the issues in the statutory qualified privilege defence were not sufficiently severable from other aspects of the case, such as to make it appropriate to deprive Network 10 of its costs of this aspect of the proceeding entirely. This is because many of the same matters canvassed relating to the conduct in publishing the project program were also in play because of Mr. Lehrmann's decision to particularise reckless indifference to the truth of the imputations as amounting to improper conduct for the purposes of aggravated damage. In my counterfactual analysis, I found against Mr. Lehrmann on this contention as to aggravated damages, and it was necessary to have regard to the conduct of the respondents in making this determination. I make one qualification to that observation, noting that this is a case where extensive contemporaneous records demonstrates a very large gulf between the carefully drafted respondents' affidavits and the true position as to the immediate and unquestioning belief in Ms Higgins' account by Mr Llewellyn and Ms Wilkinson, and as to the project team's lack of interest in examining the account properly or obtaining contrary accounts. Significant costs in preparing the affidavits by both respondents were wasted. Given my time over again, I would have been best assisted by hearing any such evidence orally. In making this judgment, I am cognisant that several deponents were not cross-examined, but as I explained in the judgment, my findings as to what occurred were not only unassisted by this material, but the real approach taken was obscured. The true position only emerged from a review of the extensive transcripts and other contemporaneous records. This picture revealed stands in contrast to the numerous representations made in the affidavits. Having determined that subject to this exception, it's appropriate that Mr Lehrmann pay Network 10's costs, it's necessary to address whether those costs should be paid wholly or partly on an indemnity basis. Network 10 submits that Mr Lehrmann engaged in an abuse of the court's processes, ran a case based on falsities and put Network 10 to the cost of defending a baseless proceeding. Given the subject matter and the success of the substantial truth defence, the seriousness of such conduct cannot be overstated, and it is of such a character as to justify an award of indemnity costs. I substantially accept the submissions of Network 10, but I would describe the unreasonable conduct of Mr Lehrmann justifying an award of indemnity costs somewhat differently. Even in final submissions, Mr Lehrmann persisted in the assertion that the evidence could not, open quotes, sustain a positive finding that any sexual activity took place, close quotes. This was Mr Lehrmann's primary case. Having said that, when it came to the question of consent, in respect of which argument was joined in final submissions, it was accepted by Mr Lehrmann that if sex did take place, the bare fact of rape, as imputed by the project program, might be committed simply by being recklessly indifferent to whether or not there was consent. What I found in the judgment is that Mr Lehrmann may well have turned his mind to consent and been aware Ms Higgins was unconscious when sexual intercourse commenced, but that I was not positively satisfied that Mr Lehrmann had a state of mind of actual cognitive awareness that Ms Higgins did not consent to having sex. In accepting the critical part of Ms Higgins' evidence that she was not fully aware when sexual intercourse commenced and did not thereafter give her consent, I found at Judgment 601, Mr Lehrmann was so intent upon gratification to be indifferent to Ms Higgins' consent and hence went ahead with sexual intercourse without caring one way or the other whether she consented. As anticipated in the submissions of Mr Lehrmann, this finding of reckless indifference as to whether there was consent was sufficient to make out the substantial truth of the fact of rape as that concept was understood by the ordinary reasonable viewer of the project program. But it is noteworthy that I also rejected two other scenarios potentially available on the evidence that ranked, open quotes, higher in the likelihood range, close quotes, than others, being that consensual sex occurred or Mr Lehrmann was not reckless while having non-consensual sex. In accordance with the fact-finding principles and cautions explained in the judgment, I rejected all other scenarios as individually and collectively less likely than what I found took place, based on my demeanour-based credit finding accepting the critical part of Ms Higgins' evidence. But even leaving aside what I found happened, any non-fanciful, albeit unlikely scenario, in any non-fanciful, albeit unlikely scenario, Mr Lehrmann had sexual intercourse with Ms Higgins and yet ran a primary case premised upon the fanciful and knowingly false premise that in the early hours of 23 March 2019 he was preoccupied with noting up details as to French submarine contracts. As I said, Mr Lehrmann defended the criminal charge on a false basis, lied to police and then allowed that lie to go uncorrected before the jury. He wrongly instructed his senior counsel to cross-examine a complainant of sexual assault, then two legal proceedings, including relevantly for present purposes in this case, on a knowingly false premise. Indeed, this was misconduct in the running of the case of such a character that even if I had not reached the level of satisfaction that Mr Lehrmann raped Ms Higgins and Mr Lehrmann was therefore entitled to judgment of $20,000, in the counterfactual explained in the judgment, I would have declined to award costs in Mr Lehrmann's favour. This would have been the appropriate exercise of discretion in circumstances given Mr Lehrmann had acted in serious breach of his obligations under Part 5B of the Federal Court of Australia Act in advancing a case he knew was false and which occasioned much delay, inefficiency and increased cost. In the end, it comes down to the order for costs that does best overall justice in the circumstances. On balance, the appropriate exercise of discretion is to make an award that Network 10 recover its costs against Mr Lehrmann on an indemnity basis, except for costs incurred in relation to the statutory qualified privilege defence, which will be recoverable, say for the costs of the affidavits to which I've referred, on an ordinary or party-party basis. As to Ms Wilkinson's costs, Ms Wilkinson makes the same points made by Network 10. Mr Lehrmann made the decision to sue Ms Wilkinson in her personal capacity as a publisher, notwithstanding the existence of the costs indemnity explained in the costs claims judgment, the same considerations that inform the making of the type of costs order against Mr. Lehrmann in favour of Network 10 apply mutatis mutandis to Ms Wilkinson. The appropriate exercise of the discretion is to make an award in favour of Ms Wilkinson in the same terms. Then I deal with the position as between the respondents. At the hearing, a process was agreed between the respondents by which Ms Wilkinson would provide various details and the ambit of the dispute would be identified. And I made a series of orders to facilitate the appointment of a referee to inquire into and report upon those costs. It's unclear whether or not one aspect of the dispute is between the respondents still needs resolution. If so, I will hear full argument on it. But as I noted during the course of the last hearing, as a general proposition, an indemnity is an enforceable requirement to hold an indemnified party harmless against loss. Consistently with the foundational nature of an indemnity, there's a well-established principle to the effect that a right of action under an indemnity crystallises when a loss or expense is incurred. Given the purpose of the indemnity is to hold an indemnified person harmless against loss, the right of action arises when the indemnified person suffers loss or incurs an expense. That being so, it seems to me, as I presently understand the position, Ms Wilkinson would have become entitled to call on the indemnity when she incurred the liability to pay properly incurred costs. In any event, these are preliminary views only, and if the timing issue that seems to have arisen between the parties requires resolution, this can be arranged at the same time as I settle the questions for reference. Orders and concluding remarks. In addition to a referee reporting upon the total amount of indemnified costs, the parties agreed that it is consistent with the overarching purpose for the same referee to inquire into and report upon the amount payable by Mr Lehrmann pursuant to the costs order made in favour of the respondents. The parties should provide by 4 p.m. on 24 May 2024 agreed or competing proposed orders for reference to my associate, not only as to the issue of the ascertainment of the total indemnified costs, but also as to the quantification of the adverse costs order made against Mr Lehrmann. I make orders for reference at a case management hearing at 9:30 a.m. on 27 May 2024. Before leaving the matter for completeness, it's appropriate to refer briefly to a further matter canvassed at the recent hearing. In the judgment, Network 10's attributed conduct relating to the giving of the Logie speech for the reason it was given, relevant conduct, was held to be grossly improper and unjustifiable as amounting to conduct apt to cause disruption to the criminal justice system and amounted to conduct that be characterised as egregious. Following the delivery of judgment, however, a solicitor spokesman retained on behalf of Network 10 made what might be described as a victory tour and expressed public comments relevant to the relevant findings and repeatedly expressed the view the Logie speech not only did not have the tendency to interfere with the administration of justice, but presented no difficulty whatsoever. In the wake of these comments, I indicated to Network 10 that it appeared open to infer and, if relevant, act upon the basis that the considered view to be attributed to Network 10, as informed by internal and external legal advice, is that the relevant conduct was appropriate and similar conducts may be made again if the broadcaster was similarly placed in relation to a future and immediately pending jury trial. Notwithstanding the position taken by Network 10 at the hearing and the comments of its spokesman after judgment, after these issues were raised, further affidavits and submissions explaining the considered and current view of Network 10 were provided to the court. This material suggests that Soul of Tarsus-like, the scales have belatedly fallen from the anthropomorphic eyes of Network 10. In the circumstances, no further comment or action from this court is necessary or appropriate. I make the following orders. 1. The applicant pay the respondent's costs of the proceeding on A, the ordinary basis for the costs incurred in relation to the defence of statutory qualified privilege pursuant to Section 30 of the Defamation Act, and B, the indemnity basis for any other costs of or incidental to the proceeding, including the costs referred to in Order 2 made on 23 November 2023. 2, notwithstanding Order 1, no costs are to be recoverable by the respondents against the applicant in relation to the following affidavits. Affidavit of Lisa Wilkinson, 2 February 2024, affidavit of Tasha Smithies, 25 January 2024, affidavit of Ms Wilkinson, affirmed 16 January 2024, affidavit of Ms Wilkinson, affirmed 5 December 2023, affidavit of Craig Campbell, sworn 18 October 2023, affidavit of Mr Angus Llewellyn, affirmed 21 September 2023, affidavit of Mr Christopher Bendall, affirmed 28 July 2023. Affidavit of Ms Laura Binney, affirmed 28 July 2023. Affidavit of Lisa Wilkinson, affirmed 28 July 2023. Affidavit of Peter Meakin, sworn 28 July 2023. 3. Pursuant to sections 37P2 and 54A of the Federal Court of Australia Act, the quantification of costs pursuant to Order 1 as qualified by Order 2 be referred to a referee for an inquiry and report with the terms of reference to be settled by the court at the case management hearing listed at 9:30am on 27 May 2024. I publish my reasons. Call the next matter.
NSD 346 of 2022, Matheson Property Group and Virgin Australia Holdings for case management hearing.